I'm glad you brought it back to the clear and convincing, because remember we talked about earlier, it's not a criminal case. We're not holding, you can't hold me to the reasonable doubt standard. I just need to make the evidence clear, and I just need to convince you that certain elements have been met then for the termination to occur, along with that it's in the child's best interest. That's the other half. So we have the clear and convincing part, and then we also have the other prong. It must also be in the child's best interests for the parents' rights to be terminated. Ms. Walker, you had a question?
Yes, I have been a juror on civil cases. So is that the same thing as the preponderance of evidence?
No. So the way the law works, there are three different standards of evidence. The preponderance of the evidence is the lowest threshold. That one we simply refer to it as, if it walks like a duck, talks like a duck, then it must be a
Okay.
duck. It's just basically just a preponderance of the evidence. That's what reasonable minds which will differ, will come up with. And then we have the next level, which is the clear and convincing, and then the highest burden, which is the reasonable doubt standard.
So may I ask a question?
Yes, sir.
So with regard to, we'll say that the preponderance of evidence is 51%.
Yes.
Okay. The beyond reasonable doubt, that would be maybe 95, 98, 99%, 100%. Clear and convincing, yeah. What is that considered? Is that an 80%, 85, 90%? What are you looking at on a percentage basis?
We try not to really put it in percentages. It's just my burden is just to make sure that the evidence that I give you is as clear, not clear as mud, but as clear as possible. And for me to kind of put a percentage on it would lead my opposing counsel over there to object.
So I guess my question would be is that, between the other jurors and myself, we might have a different idea of what clear and convincing is. The juror to my left here, Ms. Walker, might think that clear and convincing evidence is 65%. Mr. Blackman might think that it's 95%. So that's what I'm trying to figure out, because we might be rendering the same opinion, but we may have different thresholds. So that's why I was trying to put some type of a quantitative measure to the idea of clear and convincing.
Okay.
And I also have one other question after that. Go ahead.
We're going to urge you guys not to think in terms of percentages. We're just going to urge you all just to think in terms of the law. And at this time, I'm going to turn it back over to Mr. Dunlop.
Thank you very much, Ms. Moncrieffe. Mr. Dunlop, if you could unmute, please.
Yes, thank you, Judge.
You're welcome.
So, I only have a little bit of time left, so I wanted to sort of unpack some things. Yes, sometimes people describe the notion of preponderance of the evidence as a 51%, but that's not actually true. It's actually more than 50%. It's not, and there's a whole lot between 50% and 51%. So to meet the burden of a preponderance of the evidence, you don't have to get to 51%. You just have to be just that little bit amount, whatever it is, however small it is. It has to be just that much over the 50%. And that reason I want to bring that to your attention, or at least sort of make that nuance clear, is just, it's the same on the way of trying to determine what clear and convincing is in a percentage type basis. It can't be reduced in a mathematical kind of way, in that way. It just has to be that you, as a juror that we are trying to seat in this panel, will have to use what you believe to be clear and convincing. And
because my math is not good.
Well, yeah, that seems to really put us in a huge, gray area. Right. If, I'm very authoritative in my parental style, or, right, I'm kind of laid back and kind of let the kids do whatever and just say, hey, you know, not the best choice. Let's make some better choices. And they keep screwing up and I'm still going, hey, let's make some better choices.
Yeah.
So I can see, you know, parents like that being on the panel here can have some really opposing feelings or thought processes, I guess,
Right.
with, you know.
And y'all will have to, and that's part of the duty that the jurors would have to deal with. You guys will have to, once you've heard all the evidence, go back to the deliberation room and deliberate and decide what evidence that the state brings is clear and convincing. And I just need y'all to remember to hold them accountable to providing clear and convincing evidence.